Thank you.
Mr. Traft.
May it please the Court, Michael Traft on behalf of Lorraine Torrey. The issue in this case is what procedure must a Massachusetts court follow when faced with a purported judgment from a foreign country and an attempt to have that enforced in Massachusetts. The judge in this case determined that without considering any evidence or having any hearing, that the Trinidad court had exclusive jurisdiction, and Massachusetts should cede jurisdiction, and the child should be removed to Trinidad for further proceedings on this custody dispute.
Mr. Traft.
Yes.
A factual question, if I may.
Sure.
The plaintiff, the appellee here, has pointed us to the standards that the Trinidad court would use in making a determination, the custody determination, the best interests of the child. Was there an evidentiary hearing in Trinidad?
No, there was not. The only proceeding that occurred in Trinidad was there was a conference with the council, and an agreement was presented to the court in Trinidad that the mother, who had only several days before obtained a court order from Massachusetts asserting jurisdiction and asking that her child be returned here to Massachusetts, had agreed, according to the Trinidad order, to remain in Trinidad, even though her husband was a United States citizen living in the United States, and that she would assume custody of the child in Trinidad and not go back to the United States without approval of the Trinidad court.
Has your client attempted to set aside the consent agreement that was incorporated into a judgment on grounds of coercion, undue influence, fear, whatever it is?
She has not filed any proceeding in Trinidad. She has filed a proceeding here, and she has made those assertions in the United States.
Is there some reason why it would be more or less appropriate to do that in Trinidad?
I think it's somewhat irrelevant to the issue of whether Massachusetts has jurisdiction or whether Massachusetts should say that if you want to raise this issue, you have to raise it in Trinidad.
Why is it irrelevant?
Because the reason why she said she agreed to this is because she didn't feel that the Trinidad court would enforce the law, that the father of the child had influence over the court, and that she would have no alternative.
If we agree with that, can't anyone come here, with even regard to judgment of one of the sister courts of one of our states, and say, I just didn't get a fair shake in that court because there were these whisperings back and forth, and I think somebody bribed the judge, and blah, 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 so, forget res judicata, forget, enforcing that order. I want to start again here in Massachusetts.
Well, someone can say that, but then we have procedures. The whole jurisdictional procedures that you follow. Well, when you deal with the question of do you enforce that other order or not. And that's why you have some of the cases in which that's been dealt with in Massachusetts, in which a court has said, well, we have no reason to think that the court didn't have jurisdiction, that they didn't follow the law appropriately.
And what would the nature of the hearing in Massachusetts be, whether or not judges in another nation are subject to influence?
No, the issue would be whether this was a voluntary consensual, because this is a consent decree without considering any evidence. So under those circumstances, the issue would be whether there was some...
I would hope at very least that you are not asking us to have an inquiry into the nature of the judicial system of another nation.
No. No.
I thought you just said that she signed it.
That would be implicit.
Sure. Wouldn't she get on the stand and testify that she has information or facts that the judge in Trinidad was biased or had been bribed? Or, I mean,
Well-
Isn't that the nature of one of her claims?
Well, that would be the nature of one of the claims.
So
But
she's
as
got to
to
get
whether-
up and swear under oath to that. And then what's supposed to happen? Somebody from Trinidad comes up here and says, I know this judge, and he or she is not, subject to this kind
Well,
of...
that's kind of a secondary aspect of the issue. The issue really is, did she consent to this? If this is a non-consensual...
But this is part of the proof of the non-consent, is it not?
Part of the proof of the non-consent, because the question is, did she voluntarily do this?
And what's
was
the
she
rest of the
forced?
proof?
Well, the rest of the proof is what she knew, what she thought, what the arrangements were.
I thought her claim was, and I don't know whether this is supported by the record, that she had not been given access to her son.
That's correct.
As I understand it, she has custody of the child, correct? In Massachusetts.
Yes, that's correct.
And she agrees to have the child visit the biological father, who is now in Trinidad, correct?
That's correct.
And she puts the child on the plane to send the child to Trinidad.
With explicit agreement that he be returned at the end of the
With
summer.
the agreement. The father then breaks that agreement, correct?
Correct.
She goes immediately to Trinidad, correct?
She first goes to Massachusetts and gets a court order because the child is a resident of Massachusetts as determined by the Massachusetts
Right, and
court.
the Massachusetts courts assumes jurisdiction. She goes to Trinidad, correct?
Yes.
And she is denied access to her son, correct?
Yes.
And she says, if I didn't agree to sign this, I was not going to be permitted to see my son, correct?
Yes.
That sounds to me as if that's the kind of inquiry that a Massachusetts court could look into.
That's correct. And that's really what I'm dealing with. I mean, when you get to the issue of whether they're subject to influence or not, that's really kind of secondary. It's more the inquiry, just as you laid it out, Your Honor. That's the concern.
But can I
Yes.
ask you, as I understand, I mean, these facts are confusing, that the child had lived in Trinidad with the father for a period of time, then was living with the mother here in Massachusetts for some period of time, and that when the father started the action in Trinidad, he was seeking custody, correct?
Yes.
Okay. So he's seeking custody in Trinidad. She files an action in Massachusetts. She wants custody here in Massachusetts. She goes to Trinidad, and what comes out of it clearly is a compromise. She gets custody, but the child is going to remain physically in Trinidad, except with either both parties' consent or the court approval. I mean, the father didn't get from the Trinidad court everything he was asking for. Far from it.
I disagree with that, actually.
Well, he wanted custody. He didn't get custody.
Well, he files and asks for the court to determine the issue of custody. He doesn't really say, I want total custody and give me primary custody. That really wasn't the issue. You have to go back to the circumstances here. There's never been any hearing in any court anywhere. There's always been an agreement among the parties.
Courts don't have hearings when the parties submit an agreement.
Well, there's been no submitted of agreement. No, I mean, before the Trinidad proceeding was the first court proceeding
Correct, but the
that was
Trinidad
filed.
proceeding, she was represented by a lawyer, the father was represented by a lawyer, a judge gets an agreement. It's not surprising or shocking or suspicious that the judge then doesn't hold an evidentiary hearing.
No, and I'm not saying it is. But here's the point. For the first 13 years of this child's life, the child has lived with the mother. There were occasions
Well, wait a
where
minute. I'm looking at the facts that say he spent 4 years living with the father in Trinidad, and then
Not
about
really.
1 year
I mean,
here.
there are disputed allegations about the amount of time that he was there and how much time he spent with the father. We have affidavits from the mother and from her siblings who said that they had significant amount of responsibility for the care of this child during the time that he was in Trinidad and the mother was here.
All of that is very interesting. All of that is very interesting. The question is, I understand this is within a matter of days, as to which, it's the race to the courthouse door. And it seems to me that unless you can point me to some powerful statement that says where there has been a consent order issued, even if it was by 2 hours, in one court, that a second court that had jurisdiction over the case, no question about that, in fact had primary jurisdiction, because, as I understand it, the Massachusetts case was commenced before the Trinidadian case, correct?
Yes, that's correct.
What are the
Was
bases?
it? No.
Well,
Day after.
Sorry, the order, actually, there was one, this is the way it went. The order, the filing in Trinidad was the first day. The
Fine.
next day, there's a filing in Massachusetts, and there's an order in Massachusetts. The following day, there is an order in Trinidad.
Well,
So actually, the first
generally-
order is in Massachusetts.
Well, generally speaking, the place where the action is commenced, assuming that there's proper jurisdiction over the parties, assuming there's proper jurisdiction over the parties. I don't know whether the Trinidadian court had jurisdiction over your client, but she's now consented to something, correct?
On the face of it. The
What-
question is it consent? I mean, she has
Tell
said
me
that
the
she
circus-
didn't consent.
Tell
that
me
it
the
wasn't voluntary.
circumstances, not by argument, but by specific ruling where a Massachusetts court can assume jurisdiction to set aside an order of another court.
The
I mean, if
appeals...
this was Massachusetts versus New York, I don't think there would be any basis.
No. The Crescenti versus Whalen case in the appeals court was exactly, was the mirror image of this in a state situation. And that was, there was an order issued in Massachusetts, and then the party went to, I don't know if it was Utah or it was a Midwestern state, I believe, and sought an order there. And the argument was, wait a minute, there's an order from Massachusetts. They have jurisdiction. And the court said, no, they don't, because they didn't have jurisdiction when you went to the order. And you didn't have to challenge Massachusetts jurisdiction, because a court that has no jurisdiction can't issue a valid order.
Could I ask you on a different subject here? The judge seemed to rule the way she did on various alternate bases, and if she's correct on any one of them, it seems to me your client loses. And one that seems to be of importance is her decision under Section 7A, a discretionary decision to decline jurisdiction. I mean, operating the assumption that she had jurisdiction, that she could, a discretionary decision to decline it because of her view that it was based upon illegal or otherwise wrongful conduct. How is it an abuse of discretion for her to conclude that when the mother violated the Trinidad court's travel restrictions within 1 month, having made no effort to get them changed by the court and encountered this, collusion, bribery stuff, at a time when the father was out of Trinidad? How is it an abuse of discretion for the judge to conclude that was wrongful conduct, and I would be rewarding that wrongful conduct if I now exercise jurisdiction? I therefore, in my discretion, decline to do so. Where's the abuse of discretion in that aspect of her reasoning?
Because under 7A, there are quite a number of considerations that have to be followed before you decline jurisdiction. And a number of those were factually disputed based upon the evidence that was presented in this case.
Can I ask you this, though? She's proceeding under 7, and she's also proceeding under 2D. That refers to states.
Yes.
It does not refer to nations.
That's
Section
right.
14 refers to nations.
Yes.
It seems to me that we are not here, we shouldn't even be under 209 2 or 209B2 or 7. We should be under 209B14.
Except that 209B14 really refers to the earlier principles, the principles of this chapter.
Well,
that
it says to the
the
extent-
court, the other foreign court has to be operating under the same principles.
Well,
And
it's-
you start at the primary issue of jurisdiction.
Forgive me, Mr. Clapp.
I'm sorry.
It simply says, to the extent that legal institutions of other nations have rendered custody determinations in substantial conformity with the provisions of this chapter, the courts of the Commonwealth shall grant due recognition to such determinations.
Yes.
Substantial conformity, it seems to me, in part goes to in the best interests of the child, correct?
Certainly.
And is there anything to suggest that there has been any determination that this was in the best interests of the child?
Other than the perfunctory statement in the judgment, but there was no examination of what's in the best interest of the
That goes back to the
child.
question of whether or not she entered into, whether this was pursuant to an agreement, correct?
That's correct.
When it says in conformity with the provisions of this chapter, I don't take that to mean necessarily referring to what happens in a state-to-state enforcement of a judgment.
But at least it would be, it would refer back to the provisions of whether the court had jurisdiction to begin with in the circumstances in which they can exercise jurisdiction.
Would the decision be any different under the Hague Convention?
There should be no question at all under the Hague Convention, because the Hague Convention says specifically there has to be an evidentiary hearing. If you look at all the federal cases that deal with Hague Convention, there is always a hearing. There is always an evidentiary hearing. And one of the more fundamental considerations is the fact
An evidentiary hearing on what?
An evidentiary hearing on a number of factors, on whether the procedure was appropriate, whether there's some the reason for concern about the child, or whether, considering the issue...
So let's assume Trinidad was a signatory of the Hague Convention. How would what the Massachusetts courts did in this case be different?
What the Massachusetts court would have to do is specifically have a hearing and consider these factors, including...
A hearing or an evidentiary hearing?
An evidentiary hearing, because the court would have to consider where you have a 14-year-old child here whose rights are going to be affected. His opportunity to stay in the United States is going to be decided by this case. If this case goes back to Trinidad, he will never be allowed to be in the United States again. He'll never have an opportunity to have a relationship with his mother.
Excuse me, he will be able to be in the United States as soon as he reaches the age of majority. Isn't he the child of a resident alien?
No, he was born in Trinidad.
He was born in
He was
Trinidad.
born in Trinidad. But wait a minute.
And I thought
And
you, I
the
didn't mean the resident. I
Trinidad
thought you
court
said
can
his father
always
was a United
approve
States.
his return to the United States.
Well, could. But how...
His mother can go and ask the court, I want to travel there, I want to go to school there, or even I want to live there.
Right. And he's
That's
saying...
not foreclosed.
And he's standing in the probate court today. He's standing in this court today saying he wants to stay in the United States.
Mr.
No one has heard
Mr.
this child.
Kraft,
Yes.
did I hear you say earlier in the argument that his father was a United States citizen?
Yes.
Well, then he won't be, then the child...
Well, I'm sorry, not his father, the husband of the mother.
So the child's biological...
Biological father is a
Neither
Trinidad.
biological parent is a United States citizen.
Neither one.
She is a resident. His biological parent is a resident alien.
She is not a citizen.
Right. That's
And
correct.
she was not a citizen when this child was born.
Correct.
Okay. Your time is up, Mr. Slaft. Thank you.
Thank you, Your Honor.
Good morning, Chief Justice Marshall, members of the court. My name is Attorney Robert Rivers from the law firm Lee & Levine. With me is my co-counsel, Tanaz Sapanaro, and I represent the appellee, Dr. Omar Khan. First of all, I would like to reiterate some of the points that came from the court. One is it's important to understand what the posture of this case was procedurally when it came before the Suffolk Probate and Family Court. There was an action brought under 209B Section 14 to register and enforce the Trinidad custody consent decree. Custody had already been decided.
Brought by your client, correct?
Yes, Your Honor.
Yeah.
Custody had already been decided back in September of 2004 by the Trinidad court. And what Dr. Khan was seeking was to enforce the September 2004 custody judgment and the order requiring the child to be returned to Trinidad.
Was that a separate action? The original case that was filed, that's been dismissed?
The original case that had been filed in Massachusetts,
Yeah.
The mother's case.
the mother's case was a complaint to establish paternity.
Has that been dismissed?
It has not been dismissed, but I would take the position, Your Honor, that in light of the fact that there was a superseding custody consent decree in Trinidad, the terms of that decree essentially superseded the Massachusetts action, because if you look at the Trinidad consent decree, not only were issues of custody and visitation resolved, also there was resolution of child support issues that were also resolved.
Was there a resolution of paternity?
There was a resolution of paternity due to the fact that my client is on the birth certificate of the child. And my understanding is that under Trinidad law, he is the father of that child. And since he brought an action seeking custody of the child originally, I don't think there was any dispute.
The paternity case is really moot.
I would submit it is moot
He's
at
the
this point.
father, and he's got a consent decree judgment from Trinidad.
That's correct.
And he moves to enforce it under Section 14.
That's correct.
And then what does she do?
What she did is she moved to object, essentially, to having that consent decree enforced. And really, the case law that deals with how the trial court is to consider that issue at that point is really the Shira case, which sets forth a three-part standard that the Massachusetts court needs to follow in order to determine whether or not the consent decree should be enforced. First, the foreign court had jurisdiction over the parties and the subject matter.
Is that clear?
I believe it is clear.
Well, they were both there, weren't they?
They were both there, so they cannot legitimately...
Well, let's assume that she, for some purposes, she's a visitor, but I suppose you would take it at very least, although I've looked at the consent decree and I didn't see it there, that she has, by entering into the consent decree, submitted herself to jurisdiction.
Absolutely. That's the position I would take. And as far as whether the court in Trinidad that actually issued the consent decree had subject matter jurisdiction to do so, I believe that the Trinidad statute, I believe it's Section 13, specifically authorizes that court to enter such decrees. So I believe that the first part... Yes, Your Honor.
I'm sorry, finish.
So I believe that the first part of that three-part analysis has been satisfied, or there was sufficient evidence for the judge to conclude that that had been satisfied.
Let me ask you this. There have been a number of cases, and they seem to be very well settled under the Hague Convention. And I'm not asking you to agree with the recitation of facts, but let's assume that a parent living in a foreign country negotiates with, in this case, the mother living in the United States, that a child be sent to the foreign country. And she does so with an express understanding that the child will be returned. The child is old enough to fly, accompanied, unaccompanied, and the child goes. And the parent then refuses to send, the parent in the foreign country refuses to send the child back again. And the mother does some preliminary action here, maybe not, but she gets on a plane. She's expecting the child back. She gets on a plane. She goes to the foreign country. And essentially she's told, you don't see your child unless you sign a consent decree. And so she does. And she brings the child back, saying that she will stay in whatever the country is, and she brings the child back again. And she comes into a Massachusetts court, which is, after all, where she was residing. It's not as if she wasn't here. She was here living with the child. Forget about what happened early on. You know, she's living with the child. The father has consented to that. The father didn't go into a Massachusetts court before he left for Trinidad and says, I had to sign that consent decree, otherwise I wasn't going to be permitted to see my child. I had no alternative. I had no alternative. And I realize that having signed that consent decree, there'll be legal arguments that can be made, but I at least want to have an opportunity here to explain why I didn't. Shouldn't she have the opportunity to do that?
I think in your hypothetical, the real question is, where should that opportunity to be heard be made? Should it be a Massachusetts court that was not, so to speak,
She's never agreed, except under duress, to submit to the Trinidadian court. What she has is the father of her child having breached an agreement to the enormous potential detriment of her relationship with her child, and has essentially absconded with this child. Now, we know that both parents love a child, and sometimes one parent has to move. And what we most want to do is to have the parents reach agreements as to visitation rights and so on and so forth. And they did. And she proceeded, presumably in good faith, and put the child. There's no claim by the father that she didn't want the child, that she was abusing the child, that there was a ruse here. And he simply broke the agreement with her.
Well, your answer would be that she'd have to litigate that in Trinidad.
That would be my answer, but...
Just as it would be if it was a Massachusetts judgment, and we reversed it, and they went down to Trinidad and said we were coerced in Massachusetts to sign this consent decree, assuming the three factors of the Sherrar test are met, which you say they are, and they probably are. The Trinidad court would say, take a hike and go back to Massachusetts, wouldn't it?
I think that's correct, Your Honor, because I think what you have to do is you have to understand or have an understanding as to what the evidence is likely going to be and where is the appropriate forum for those types of claims to be made. There was a judge that presided over that hearing, obviously had an opportunity to observe the parties.
Well, he didn't preside, or she didn't. I can't tell if the judge is a man or a woman.
It was a woman, I believe.
I think it was a woman, yeah.
She did preside over the matter. She actually has also submitted documentation regarding her knowledge of what transpired at that hearing, which is in the record.
Right, I've seen that.
I would submit that the proper place to raise issues of coercion, it really is the collateral attack issue as to whether or not...
Well, I have to say that it is troublesome because, to force somebody who has no intention of going to a foreign country, I mean, assume, for example, that you're a United States citizen or you've lived here all your life and you work and so on and so forth, and you really do proceed in good faith. And you're saying, terribly sorry, I can abscond with the child, I can keep the child, and I'm going to force you to come millions of miles away, I'm not saying Trinidad is millions of miles away, and force you to litigate here.
Well, I think if I can just come back to the facts of this case, I think it's important to understand the reasons why my client proceeded the way he did when he did.
Has your client suggested at any point that he had not agreed to return the child?
He has not, but I think what you need to understand is that there was some
she has made a clear claim, and it appears to be...
He's made a claim that she did the exact same thing to him the prior year. That's the reason the child was here, was that she had reneged on the agreement to return him to Trinidad. Both sides are accusing the other of the exact same form of underlying misconduct.
But the other thing I'd like the court to keep in mind is that when my client brought his action in Trinidad, as you can see in the affidavits that he filed in Trinidad, he was alleging that there was a family situation in Trinidad that he felt was not in the best interest of the child. And he was proceeding...
In Massachusetts.
In Massachusetts. And he was proceeding on that basis to ask the court to address the issue of custody. So I think it's somewhat different, Chief Justice, than the hypothetical you gave.
No, that's why I said I'm not asking you to agree with the facts. I'm asking you, I mean, it may well be, but I'm just saying where you have that situation. Under the Hague Convention, no question as to what happens here. Trinidad is not a party to that convention. I don't think that is necessarily determinative, but...
Right.
Now, you started out with the Sherrard test, and you went through the first part.
Yes.
Namely that she was there and consented to jurisdiction, the court had jurisdiction. What are the other two parts?
The second requirement is that the procedural and substantive law applied by the foreign court was reasonably comparable to that of the Commonwealth. And again, I would submit that there was...
What does that mean?
What that means is that...
The Commonwealth, the consent document that's signed under coercion is no good.
Well, I think what has to be made is a determination as to whether or not the law of the foreign jurisdiction applies what we call the best interest of the child standard.
Oh, okay.
Now,
they do that.
There are other cases that have been decided by our appellate courts that have addressed that particular issue specifically. For example, the Taziz case. In the Taziz case, there was a question as to whether or not the court in Israel that was involved in the proceedings applied a best interest of the child standard, because it was alleged that the law that's applied is a religious law, and because it was alleged that it is a male-dominated society, that women are not treated equally, and that a best interest of the child standard is really not applied. It's really almost a gender analysis, where the male has all the rights and the mother has no rights. So that's the situation where the best interest of the child standard comes into play. But in this case, I would submit that there can be no genuine dispute that Trinidad, as a matter of law, applies a best interest of the child standard.
Well, that's the third part of the test.
That's right.
So what's the second part? Procedural and substantive law have to be comparable.
Right. The second part is that there are due process rights that are applied to people, that they're given the right and an opportunity to be heard. That is one of the procedural rights. I would submit that a right to appeal a decision would also be a fundamental right.
Those are procedural. I'm really interested in what...
Well, the substantive law would be the standard that's applied in custody cases.
Well, that's...
But
because the third part specifically mentions the best interests of the child.
But the third part says that the foreign order was based upon a determination of the best interest of the child. So while the second part says there has to be a best interest of the child standard, The third part says that standard had to have, in fact, been applied in the case pending before the probate court. So it's not enough to simply say the court has a best interest of the child standard and that's enough. You have to make sure that that was applied. But I would submit in the facts of this case, there really can be no genuine dispute as to whether or not a best interest of the child standard was applied. The mother received the exact relief that she was seeking in Massachusetts. She obtained custody of the children. That was the same relief that she was
Well,
seeking.
let me put it this way. That's not exactly the same relief, because if I'm living in Massachusetts and I agree to, I accept custody, or custody order says, fine, but as long as you're living in, Uzbekistan, I mean, it's not the same relief. And I suppose, one of the things that I was trying to look at is what happens when there, in fact, where there's a claim of coercion. I'm not asking you to say that there was coercion, but there's a claim of coercion. I agreed to this because I was being denied access to my child, but I brought the child back to the United States in the good faith belief that a United States court would protect me as a United States citizen. She's not a United
I
States
wonder,
citizen.
could
No,
you
I'm
clarify?
deliberately trying not to make it. I don't want to have Mr. Rivers in any way thinking that I'm suggesting it's his facts. I'm just looking at what happens in those circumstances.
In
Where
those
there's no evidentiary hearing.
I would submit that there is, the proper procedure is to proceed in that court that
I know
issued the
that,
order
yeah.
and determine whether or not there was coercion, not to flee to another jurisdiction and ask the other jurisdiction to
Well,
engage in
you're
that
not fleeing to another
analysis.
jurisdiction. You're essentially coming home where somebody has kept your child.
Is this Trinidad court a court of record? If, in fact, she is sent back there and chooses to go back to litigate this issue, will they have a transcript or a recording or some such thing?
I did look into that as to whether or not there is a transcript, and with respect to the consent decree that was entered, there is not a transcript of that hearing.
Well,
There is a,
I could see that happening, but what about an actual trial down there, or whatever they call it? You don't know?
they do provide that there can be evidentiary hearings in Trinidad if it's appropriate.
I'm sure they do, but do they?
What goes up on appeal? There is a right of appeal down there, but what goes up on an
Yeah.
appeal? Is there a transcription of the lower court proceedings?
My understanding from talking to Trinidad Council, and I'm getting this all from Trinidad Council, is that what happens is the judge that presided over the proceeding issues somewhat of a memorandum as to what transpired, and that is what forms the basis.
And there is
of-
an appellate right.
Absolutely.
What is their system? Is it French, English?
It's based on English common law,
It's English.
Okay.
so it is based on the same law as our court.
And I take it that there's an order that this child is now a ward of that court?
Yes, and if I could just briefly, I know my time has expired, but on that issue, having spoken with Trinidad Council, my understanding is that when a child is made a ward of the court, that is a matter of course. It does not signify that the court is
No, I
taking-
understand
No,
that.
it's just
I understand that.
it's just legal terminology
Right.
for
It has
the
not-
fact that they've got jurisdiction
At
over
this
it.
time, there has been no determination.
Yeah, it's not like sending the child to the DSS or something.
That's
No,
right.
no, I understood that. But
I see that my time's expired.
thank you,
Thank
Mr.
you very
Rivers.
much.